quickly want to bring in Prashant Patil into this conversation. Prashant Patil, the court says the juvenile was also in trauma. Sir, how was the juvenile in trauma driving an unregistered Porsche, allegedly under influence of liquor, reportedly at high speed, and killing two young IT professionals who were barely 6 years older than him?
Sir, honestly, I've been invited today only to brief on what was the writ of habeas corpus that was moved before the Honorable Bombay High Court. And I can only speak on what was argued before the Honorable Court and what is the outcome of that particular writ petition. I will not be able to speak on anything else more than the purview of the writ petition. So maybe if I can just stick to what was the writ petition about, what are the grounds raised before the Honorable Court, and what are the directions of the Honorable Court, I'll be able to maybe brief the viewers on this.
Sir, fair enough, because I fail to understand how is that minor or that juvenile in conflict in law in trauma, and that trauma being compared to the trauma of people losing their lives. But fair enough, go on, sir.
So, as we all know, on 19th May 2024, the child in conflict in law was granted bail by the Juvenile Justice Board. On 22nd May 2024, the particular order of granting him bail was later on modified, and the same juvenile or the child in conflict in law was put under detention at an observation home in Pune.
Sir, if I may briefly interrupt, he was granted bail, and one of the conditions was write a 300-word essay on road safety.
Sir, again, as I say, I will not be able to comment on any orders of the Honorable Juvenile Justice Board or Honorable High Court. I can just brief you what was the writ petition about, because I was invited on that time.
Go on, sir.
When I was told.
Go on, sir.
So, on 5th June 2024 and on 12th June 2024, the so-called detention of the child in conflict in law was extended by the Juvenile Justice Board. So, the paternal aunt of this particular child in conflict in law, the CCL, he moved a writ of habeas corpus before the Honorable Division Bench of Bombay High Court. The main ground, the main crux of the entire petition was the Juvenile Justice Act. We did not make any allegations against any kind of prosecution. Our only submission was Section 12 of the particular act, the Juvenile Justice Act, clearly lays down what is the law as on today. And that law says, be it a bailable offense or a non-bailable offense, the Code of Criminal Procedure Code is not applicable when it comes to a child in conflict in law. Based on that Section 12, we had prayed on 19th May for the release of the CCL, that is a child in conflict in law, and on the same basis, we again moved the writ petition before the Honorable High Court. Honorable High Court heard both the sides, as in the defense side, that is us, the petitioners, and also the prosecution at length 3 days ago. The matter was reserved for orders to pass today, and the Honorable High Court has come to a conclusion that maybe Section 12 is applicable in this particular matter. The scheme of Juvenile Justice Act, the entire scheme, sir, this is what I'm trying to tell you, is drafted in such a fashion by the legislators that the child in conflict in law is the epicenter of that particular act. And he has to be dealt according to the scheme of the act, and no one can cross that purview of the code, the Juvenile Justice Act, based on which the Honorable High Court has granted this directives today. We'll have to wait for a reasoned order to come out, because we do not have the uploaded order on the website. Once it is out, I'll be able to tell you what exactly are the ingredients.
You know, sir, this is such a sense of deja vu. We had covered that Nirbhaya case. Of course, no two cases are alike. But even there, the juvenile in conflict with law, after the most heinous crime, got away because child in conflict with law, this does not draw the CRPC. And, you know, as my only point is, perhaps it's time for our lawmakers to sink their differences and come together and look at this. Look at this, that a 17-year-old is old enough to drink illegally, old enough to get behind the wheel of a unregistered Porsche car illegally, and two young IT professionals, उनके माँ बाप ने क्या क्या परिश्रम करके उनको इंजीनियर बनाया और उनको रौंद दिया गाड़ी के नीचे, and then you can come out of jail, where the family stands accused, Mr. Patil, the family stands accused कि juvenile का blood sample बदल दिया, so that there is no remorse, Mr. Patil. They play the system. That's the allegation, Mr. Patil, isn't it, sir? Do you change the blood sample of the drunk individual, juvenile in conflict with law, and the mother's blood sample is put?
Yes. Again, at the cost of repetition, so what I'm trying to put across is we will restrict today's submission only on what the writ petition was. there has been investigation in the matter because we are at the fag end of that investigation. If certain things have happened and it is in the purview of the investigating agencies, they have also reported to the courts. The matter is still pending before the courts. At this stage, as a lawyer, at least I will not be able to speak on the evidence part of it because it is sub judice before the honorable courts at Pune. I can only say the first part of your observation I am completely in consonance with. I definitely agree with you that if you require any amendments of the Juvenile Justice Act, it is for us, as in you and me and the citizens of this country, to raise up this issue before the Honorable Parliament. It is for the parliamentarians to maybe amend the particular act.
You're absolutely right, sir.
Today,
because we have to look at this case as human beings. What kind of a society are we becoming? We were on the streets reporting that Nirbhaya case and that juvenile in conflict with law
on that
got away with rape and murder. And
can I add that?
Go on, Mr. Patil, because I'm appealing to your good sense as an officer of the court and as a member of the society.
Absolutely. And as the member of the society and officer of the court, there cannot be any disagreement on the fact that whether certain provisions of the law may be revolved or maybe evolve and then they have to be amended, but that is for the parliamentarians to decide. But there is something very important that I wanted to point out. Please understand, we have a judgment of the Honorable Supreme Court directly on this point that we are talking today. There is a direct judgment of the Honorable Supreme Court, and the Honorable Supreme Court at length has deliberated on that judgment that whether 304 IPC, let's consider the maximum stretch of this particular incident of it being an accident. Whether it's 304A, 304, 304 Part 2, I don't want to sound this argument very technical. But whether this particular section, will it amount to a quote-unquote heinous offense according to the Juvenile Justice Act? And the Honorable Supreme Court has clearly laid down the law saying 304 IPC cannot be treated as a heinous offense.
Sir, but if a man knows that he is going to drink and he's going to drive and drinking and driving is going to cause death, it is not an accident. It should be culpable homicide. It may not amount to murder, but it is not an accident. But I want to bring in the victim's mother. Sir, stay with me. You're an officer of the law. And today this conversation has to be for a better society.
Yes, absolutely. Can I just add, as an officer of the court, my humble request is this. I was called today to only submit on what was the contentions of the writ petition.
Sir, point taken entirely.
With due respect, I will definitely, I'm consonance with you, I'm in complete agreement with you, and there cannot be any disagreement of the fact that whether the act would require an amendment, maybe at the stage of parliament, it is for the legislators to decide.
शराब पी के नशे में धुत 2 करोड़ की गाड़ी 200 किलोमीटर रफ्तार रोन दिया 2 बच्चों को, मतलब उनका भविष्य सोचिए. You've destroyed 2 families. And
on that stage, I will not be able to speak on the evidence.
I want to bring in Savita. I want to bring in Savita Vadhya.
I will not be able to.
No, fair enough, sir. Point taken entirely.